Good morning. Better late than never. I apologize for being late. Yes, I'm late. 1 minute. I apologize. Anyway, I hope everybody's well. I have to straighten the cap. However you do that. There it is. And here I am. I was out of town for a week or so doing various things. So I'm back. Wanted to do a quick live stream. I had 3 things I wanted to talk about. Not legal advice. Like, subscribe. Follow me at Not Legal Advice on X, since my other account was never corrected. Not obviously with K, so one word at Not Legal Advice. Like, subscribe, share, whatever all that nonsense is, which I don't say very much. So what I'm going to talk about quickly is I'm going to talk about the short ban potential, GTII current, and I want to talk about a Supreme Court case that might affect us all, and Finra, and I'm going to go over that as quickly as I can. But before I start, of course, as we do every day, and I'm going to do by the way, I will do I think JR and I are going to do a live stream, I think tomorrow night probably. We're going to talk about the Supreme Court case that I'm going to reference at the end. But before we go there, just quickly, did you hear about the shepherd who drove his sheep through the streets and got a ticket for making an illegal U-turn? That is the joke, by the way. That was the end of the joke. E-U-E, by the way. What did one DNA say to the other DNA? Do these genes make me look fat? And last but not least, and you probably already know the answer, but my IQ test just came back. The results were negative. And I'm sure you guys knew that without me even saying that. So going forward, so I wanted to talk about the 3 things I mentioned. So first is the short sale ban. So I heard, I think I saw it yesterday in multiple locations, and I spoke to somebody and they talked about it to me also. And it appears that the current administration is seriously considering imposing some type of short sale ban. I don't know, the extent of it. I don't know, and I think I posted a tweet or an X or whatever you call that when you do something on X. I did yesterday suggesting that I had heard that, and I think it's seriously being considered as opposed to just BS. And it may be, personal interest in mind. For example, DJT, which is the president's own entity, or he's affiliated with that, also apparently was heavily and maybe improperly shorted. And I know Devin Nunes was associated with that, and I think they were pissed off about that situation. And so it wouldn't surprise me if there wasn't a ban. I don't know, because there would be a personal interest in that also, because it might impact DJT. But I don't know what type of ban it would be. I don't know how long it would be. I don't know the likelihood of it. I don't know the political wranglings of it. I don't know who's contributed what and who might have an interest. So I don't know. And then on top of that, we don't know if there will be. So let's assume, for the sake of discussion, because that's what we do, and speculate, because we like to speculate here. If it's imposed, the questions then would be, would the shorts have to cover? So if there's existing short positions, would they be required to cover during this short sale ban or not? And if they were, would they have a period of time to cover? And what would that period be? And if they didn't, or if somebody else shorted during that ban, what would the penalties be? And who would be enforcing those penalties? And what would the ramifications be? So we don't know what that will be, but it seems like it's under serious consideration. So, and I don't know, which stocks would be most impacted by that, but you would think, just speculating more as I like to speculate, that stocks that had high short interest might be impacted more than ones that had low short interest. And it also might be the case, this is a concept, I was thinking about this. Can you make something happen by just talking about it? So if this, so I saw it somewhere, and now I'm talking about it, and I'm sending it to you, and now you'll probably talk about it. And as we continue to talk about it, does that discussion itself then cause shorts to have concerns about something happening? And is it a self-fulfilling prophecy in that way? In other words, so I'd say just keep on discussing it, make the shorts concerned that this is actually going forward, because it may not require the ban. It may be that the threat of the ban might force the shorts to close. So I'm one who I fully support any ban, no matter what the ban. I do. Any ban, no matter what the ban is I think a positive move. But I believe the threat of the ban is just as good. So circulate this thought that you've seen it, you've heard about it now. You could discuss it. Maybe you have a different opinion on it, but circulate it. Speak about it to your friends. Make your opinions, whatever your opinions, make them known so that the shorts understand that it's a real issue and they may have to deal with it. And again, I don't know which companies per se would be most benefited by those, and I'm not going to recommend any, but I would think any company that had a high short interest might be positively impacted by the threat of a short ban. So that's my 2 cents on that. Follow that. I will, I'm sure if the ban goes into effect, all of us will know about it, and I will obviously make it known when I find out about it. Okay, so that's the short ban that I saw and heard about yesterday, and again, that I believe is in legitimate consideration. Again, I don't know terms. Second part was GTII. So my and I've let's just say I have very good sources regarding GTII, so I feel comfortable when I'm speaking about it. So I'll go forward on that along those lines. My understanding is that negotiations are still ongoing and progressing. I think everybody's trying, moving forward with the hope and expectation that a deal can be facilitated. I know the target company AIversity is acting, as expeditiously as possible and is interested in consummating a transaction that kind of fits within what the parameters were that we've discussed before. And one of the issues, obviously, in the negotiations, and one of the issues that John Forster raised, and it makes perfect sense, was the issue of bringing back shares, the shares that maybe are of questionable source. So those would be shares where somebody ends up with them, and there's no reason they should end up with them in good faith. Either they haven't been paid for them, or they haven't provided services, or there's no evidence of that. So there's a lot of those shares. I think when Mr. Forster was on with us, he estimated, I think it was him, he estimated about 100, or maybe it was the receiver, I don't remember which one. They estimated around 190 million shares of questionable, let's say, questionable consideration. It may be slightly less than that, but I mean slightly. It might be 185 million. And everybody understands that those shares, or some workaround around those shares, it's a necessity for completing any transaction and staying in business, really. And I think that's the main issue that's still being discussed. I know that this is an ongoing discussion since the court approved the parties to see if they could finalize the terms. I know that there's been multiple discussions involving multiple issues, but that this or a workaround are the primary issues that are, I guess, in they're working on. Let's just say that. So when I have more information about if they've progressed beyond negotiating that particular issue, I will obviously let you know. I think if that issue is resolved one way or the other, then that would probably facilitate the conclusion of the deal, but I don't know that for a fact. But that's my impression. With regard to the GTI case, there was a hearing last week, I believe, involving a couple matters, but one involved issue of contempt, I think, versus Justine Reichman or .8, which is an entity I think that she was associated with or claimed to be associated with. I don't know which one the hearing was regarding. because I think the allegation is that she's also associated with .8. But be that as it may, there was some kind of contempt hearing where the party, and this it would be the Receivers Council, had supplied some type of subpoena to either Reichman, Ms. Reichman, or to .8, and I guess there was some allegation they hadn't complied. Then there was some agreement that there'd be further production of documents. I guess it happened, but maybe they hadn't fully complied to the extent that the Receivers Council wanted. So there was a hearing then trying to enforce compliance with the subpoena, and based on non-compliance, and that's what a contempt proceeding was. And so there was a hearing. Apparently, the judge said, "See if you guys could figure it out." That's how that part left out. And as to .8, it was suggested, because there's going to be an attempt to, I think, repatriate shares that went to .8 that perhaps shouldn't have gone to .8, or that's the allegation of the Receiverships Council. And I'm not going to dispute that, because I think there's a lot of questionable transactions here, as we all know. But the court apparently seemed inclined to cancel or to bring back those .8 shares, which would be to the benefit of all of us, obviously. But there was no final determination on that, and obviously there's no final determination in contempt, because that is still ongoing. Now, one of the issues that came up, and this is as to, I think, Justine Reichman, is, and again, I wasn't there, but apparently the judge expressed some question as to having a personal jurisdiction over Justine Reichman because she resides in California. So personal jurisdiction, in other words, the court has to have the power to impose its judgment over a party. And so, if there's a court in Nevada and I live in California, it's not obvious that a court in Nevada can have control over somebody in California. So that's the issue. And the greater issue is there's property in California. So the question would be, can a court in Nevada impose a judgment about a property in another state? So I have, on multiple occasions, suggested strongly, let's just say strongly in quotation marks, for Receivers Council to initiate an action in California as to all real property there, because I think that's the proper place to do that. They have not yet done that. I don't know why, and it's annoying me. Let's just say that. But I've suggested it multiple times, and it's not been done yet. I hope it's in process. It should be in process. And I think as to that property, if I were on the other side, I'd argue California was the appropriate place to challenge, or to attempt to obtain property sitting there. So I think an action should be filed in California to the extent that the receiver wants to go after the real property that we all know about, because in the receiver's reports, we know that there's a property in Marin County. I think there was a property in Los Angeles. And there's no reason, I think, for the Receivers Council not to pursue that in California. That's the appropriate place. And that would be to me, that would be the cautious way of approaching it. And also, I think it would provide us the most leverage, because I think it's the most appropriate place. And I've said this, so I'm just saying it out loud. So what would happen? So if you file a lawsuit against a property in California, at the same time you filed a lawsuit, you can file something called the lis pendens, which is basically a notice to everybody in the world that there's a lawsuit affecting title, right to possession title, involving that particular property. And it also means that that property can't be sold, you can't borrow against it, and it's frozen out. And I've suggested that be done on multiple occasions, hasn't been done. I think it's high time that be done, and there's no excuse for it not being done. If it is in process, then great. If I've expressed myself enough to encourage them to move forward with that, then great. But there's no excuse at this point in time for not moving forward. And obviously, it's a leverage point for us. And if the Receivers Council, based upon the receiver's reports, agrees that that property may have been improperly obtained through means involving the sale of stock involving GTII, then the Receivers Council needs to act. In my opinion, just my opinion, and I've asserted that on multiple occasions. So, sometimes I don't talk about that. I usually don't talk about what my particular discussions are specifically. This is one I'm annoyed about, and so that's why I'm discussing it. I wasn't even planning on discussing it, but that's why I threw it out here. So that's what should be done, and it should be done immediately, and there's no excuse for not doing it, and I'll leave it at that. I've kind of beat a dead horse. I believe that the receivers, and I haven't heard it publicly, but I heard it in the back. I don't know where I heard it, so I'll be honest. I don't know where I heard it, but I believe it is true. Previously, I think the receiver indicated that the audit would be completed March 31st. I recently heard it might be 2 weeks later, mid-April. I don't know if that's changed, and I don't know if it's accurate, but that's what I heard. So if we were expecting a document on March 31st and it doesn't happen, then it would be consistent with that. But I don't know. And I don't think it's real, another couple extra weeks, that sucks, but I don't think that's, I don't think that's a big deal in the grand scheme of things. If that continues to drag out, then that's going to be, again, a little bit of an annoyance, because this is not just circumstances, by the way, not attributing any fault to anybody, but just circumstances. Sometimes things get delayed, but it's kind of an annoyance, and we all want to move things forward. We want to get the company trading. And again, the brief, by the way, this is sponsored today by Burger King. The faster the audit is completed, the faster we can get it back to trading, the faster the deal with AIversity can be completed, if it can be completed, and the faster we can move forward. And I know, again, like I said, I know I don't have direct conversations with the receiver, but I know from the target's perspective, AIversity, they're anxiously wanting to move forward and interested in completing this transaction. I'm sure the receiver is too, but I haven't had as much discussion directly with the receiver, and the receiver is represented by counsel directly. So it's harder to communicate directly with the receiver than it is for me to communicate with the target. So just to put it all up in the air there. Last but not least, and this one is a huge, and I don't think it's been talked about much. Again, sometimes things slip through the cracks. There's a case called FCC versus Commerce or something like that, that's being argued tomorrow before the U.S. Supreme Court. And it's the issue is there is and why am I talking about this? There is an issue here that potentially affects Alpine, but also, and Alpine, as we know, is the prime broker who worked on GTII, right? And we think, at some point in time in DTC documents, it refers to a concentrated short position, and perhaps there's a short position, and some people believe that could be, that might impact the stock value at some point in time. I have no idea, other than I've seen the documents that reflect a concentrated short position, but I don't know if that still exists, and I don't know what that really means. But that's what other people believe, so I'm throwing it out there. So Alpine is involved in a bunch of litigation, and in they have filed something with the U.S. Supreme Court, asking the U.S. Supreme Court to rule on whether Finra should have a right to exist. And one of the things that they asked or asserted, one of their arguments is called the non-delegation doctrine, which means that, and it says, there's three branches of government, and Congress is the one has the rights to set up, agencies, but they can't just delegate their authority without supervising and giving specific rules or clear rules. Actually, the standard, I think, is an intelligible standard, something like that. It's got to make sense. It doesn't really make sense, but it literally is something like intelligible standard. But so if Congress sets up an agency and the agency acts, there has to be some specific guidance, and Congress has to oversee that. And that's what the non-delegation doctrine is. And I think in the Alpine case that's before the Supreme Court, well, it's not quite before the Supreme Court yet, they've asked that the Supreme Court consider it. In that case, one of the arguments that Alpine makes is non-delegation doctrine, that Finra shouldn't exist because that's an improper delegation of authority to Finra from the SEC, which is indirectly from Congress, and Congress is not supervising either SEC or Finra. So that's kind of the argument that Alpine makes. But there is and we don't know if the Supreme Court's going to take or consider that case. The Alpines asked for it, but we don't know what the court will do, whether they'll take it or not. And I don't think they will because of the facts, but they might. But I don't think they are. But there's a case that's currently before the Supreme Court that's going to have oral arguments tomorrow, and the decision will come out before the end of June, because that's the end of the term. And in this case, the FCC set up some type there's a statute that requires, it's called 47 USC section 254, if you have any interest, that basically says that there's an obligation to provide universal service to the country, no matter where you're situated. And to do that, each company has to provide some type of subsidy to fund that universal service. And that determination is made by the FCC based upon some statute, and they used a private entity to do some of the tasks involved with that particular issue. So the issue, again, is the subsidy, how much it was, and how it was administrated. That's kind of the issue. And we have an agency who utilizes the services of a private company to administrate that job. So the issues that are being considered are whether Congress violated the non-delegation doctrine by authorizing the FCC to determine what the proper limits were and what the amounts should be, whether that was. The second question is whether the commission, so the FCC, violated the non-delegation doctrine by using the administrator's financial projections in completing its evaluation. That's in using a private company's information and analysis. And the last question is, and these are the questions that are presented to the Supreme Court, and that's what they're going to decide, whether the combination of Congress's conferral of authority, the fact that Congress gave the FCC the authority on these matters, and then the fact that the FCC then delegated certain responsibilities to a private administrator, did that violate the non-delegation doctrine? And that's what's going to be heard and decided. So, but why is that interesting? One, non-delegation doctrine, as I indicated, is an argument that Alpine's using to, and I think others are going to try to abolish or limit FINRA or its powers and authorities. And what in the questions, that's why I read the questions to you, what in the questions makes me, causes me to wonder if this is going to apply directly to FINRA. So if I just substitute names, that's kind of how I looked at it. So the fact that Congress delegated responsibility to the SEC to supervise everybody without specific standards, does that violate the non-delegation doctrine? That would be a question that I might ask if I were challenging the existence of the SEC or FINRA in any of these cases that might go up to the Supreme Court. And depending on the outcome of this case, if this case rules as to any of these issues, and it could say, by the way, I just read one, it could say no, it doesn't. That the fact that Congress delegated to the commission to basically set the actual amounts, that may not be a violation of non-delegation doctrine. The second one says whether the FCC delegating responsibilities to a private company, does that violate the non-delegation doctrine? That seems to me very similar to the SEC delegating responsibilities to FINRA, but it's substantially more, because in this case, the private administrator was limited to very few functions. In our situation, FINRA has broad powers to act without seeming limitation by the SEC, or very limited limitation by the SEC. And Congress is nowhere to be found, obviously. So I think in our case, if we're Alpine arguing this, for example, I think this is a much stronger argument because of the power that Finra, also a private company, has compared to the administrator, who is a private company here. And in the last one, so I think if the court ruled in this case that because the SEC uses because in this case the FCC, excuse me, because the FCC uses a private administrator, that violates the non-delegation doctrine, then I think the court would rule that the SEC using Finra violates the non-delegation doctrine, and they could rule that Finra's existence would be unconstitutional. That's a possible conclusion. The last one is whether Congress giving the authority to the SEC and the SEC then delegating that to a private company violated the non-delegation doctrine. And again, I think we could substitute Finra here. Did Congress giving authority to the SEC and the SEC giving it to the private company, Finra, does that violate the non-delegation doctrine? I think in our case, it's substantially, again, stronger than this particular case that's going before the Supreme Court tomorrow, because the duties, responsibilities, discretion of Finra are substantially more than the private actor here. And I think if the Supreme Court finds that in this case that there's a violation of non-delegation doctrine because of the joint Congress giving up authority and the private company, I think involving Finra, I think there's a greater likelihood of finding that, and a greater likelihood that Finra's either would be abolished or restricted in terms of its power and authorities. And again, that's my opinion. I'm not a constitutional scholar, just some guy just speculating. But when I saw this, I was wondering, why there wasn't a lot of comment. Where I saw the comment, ironically, was in the discussion, I think, of in the application that Alpine made to the U.S. Supreme Court. There was a discussion by multiple parties about this particular case and kind of how they were all kind of waiting for a determination about this particular case. I will be watching the oral argument tomorrow, and like I said, JR and I will be doing a live stream either tomorrow night or the night after about it, to kind of give you our spin on it. But I think it's potentially really impactful on FINRA and the SEC, and could result in the possible abolishment of FINRA, and might provide a justification also for its abolishment independent of this decision. In other words, if let's say the Supreme Court rules that there's been a violation of non-delegation doctrine, is this an agency or a bureau or whatever you call FINRA that can exist or can be reduced and terminated? And I think it's an interesting question. And the result of the Supreme Court, I think, will provide ammunition to both sides, depending on how the court rules. And I'm really anxious to find out how the court rules on this. There's one caveat. There's one argument whether the case might be moot. In other words, it may not be, the court shouldn't consider it because of some failure to exhaust all their remedies before the Fifth Circuit. I don't think, that's possible. So in other words, sometimes you can't go to the next level without doing everything you can at the lower level. And if you don't, and you go up to the next level, a higher court, they won't consider it. So that's kind of the argument. But I don't think the Supreme Court would have taken the case if that happened, if they thought that was really a determining issue, because otherwise it really wouldn't make, unless that's the point they want to make, it wouldn't make a lot of sense that they would deal with this constitutional issue and resolve it on a procedural issue. I would guess they probably would have just rejected the request and they wouldn't have heard the case. But you never know. But those are the three little questions. I know it's complicated, but it's basically, can Congress give authority to an agency and the agency then give responsibilities to a private company without very specific controls, language, etc., intelligible language. And we'll see what the Supreme Court holds. Again, decision will be before June. The oral arguments tomorrow. Again, JR and I will let you know what we think for whatever that's worth. And it may not be worth very much, obviously. But that's about it. And that's all I wanted to talk about today. Hope everybody is well. Hope that was information is helpful and interesting. Be well out there, everybody. Take care. Have a great day. Talk to you later. And I'm going to say